Hey there, I'm Perry Russum, and this is Burden of Proof, where we cover high-profile cases every day. A lot to talk about today, including the defense resting in the Lindsay Clancy trial. There was also more testimony in the Tupac murder trial. I am joined by two illustrious lawyers. To my right, criminal defense attorney Brian Buckmeyer. Hey there, Brian.
Hey guys, how's it going? A lot of interesting updates today.
It's been an odd 24 hours.
It's been an odd week.
Yeah, for sure. And then to my left, criminal defense attorney and former prosecutor Bernarda Villalona. Hey, Bernarda, how are you?
What a week it's been. I feel like I've heard from so many doctors, more doctors than I've seen in my whole life this week.
My favorite thing about doing the show is learning so much from you guys and from these cases. This whole thing has been a learning experience, so thank you for a great first week, and here we go. All right, so before we get into all the legalities, let's start with the Lindsay Clancy trial, the woman who killed her children back in 2023. This happened in Duxbury, Massachusetts, just outside of Boston. This is an incredibly sad story with 3 children killed. They were between the ages of 8 months and 5 years old. We know the defense has rested. Her legal team called up family members and psychiatrists who treated Clancy in Massachusetts as part of their case. Her lawyers say she suffered from postpartum psychosis and should not be held criminally responsible. So after the defense rested, the prosecution then presented its rebuttal case. They called up a forensic psychiatrist who interviewed Clancy. He said she suffered from a major depressive episode, not psychosis. So it's this whole, did she have psychosis? Did she not have psychosis? Let's bring in Peter Haralambous. He's been covering this case very closely for us. So Peter, I want to start with the defense here. They called their last witness. They're all done. What do you think they try to accomplish this week with all of their witnesses?
Yeah, Perry, I think in this case, the defense was really trying to accomplish 2 things. The first was that Clancy was trying to seek help. The prosecutors have argued she jumped around from provider to provider, medication to medication, not really making an effort here before she decided to take her own life and her children with her. What the defense did this week was call family members, call her mother, her sister, even her mother-in-law, each of whom testified that Clancy was trying to get help, that she was desperate to find a way to fix her symptoms without hurting her sleep and to be a good mother at the same time. The mother-in-law, in fact, actually helped connect her with a provider and helped her manage the side effects of those medications, really highlighting that she was trying everything she could to improve her condition. Second, it was to highlight the postpartum psychosis. They called psychiatrists and psychologists who treated Clancy, who evaluated Clancy's records to argue that she was in the throes of postpartum psychosis. They also called a hospital chaplain who met with Clancy more than 200 times. She recounted a meeting with Clancy about 1 week after the killings where Clancy was just beginning to speak. She was just extubated. And she basically said that she was glad her children were safe and that she heard a male voice telling her to do all of this. This is, again, really at the heart of the defense case, this idea that she was in the throes of postpartum psychosis. She could not tell what was real from what was fake, what was right from what was wrong, and that's what led to this tragedy.
Yeah, the story is chilling on so many levels, and as more information comes out, it's resonating with a lot of people. How do you think prosecutors pushed against that with their own rebuttal?
Yeah, we'll have to see how this works out over the next day when testimony resumes on Monday. For now, the jury heard from one more psychiatrist. He was called by prosecutors as part of this rebuttal case. We understand they might call a few more of these experts, but this expert, he is someone who evaluated Clancy's medical records and met with her twice, Avram Mack. And he basically testified that in his understanding of all of this, Clancy was methodical. Clancy knew what she was doing, in his opinion, and Clancy knew the difference between right from wrong. He really pushed back against this argument about postpartum psychosis. We expect these 2 other rebuttal witnesses to basically say the same thing. The other thing we expect prosecutors to do is really just highlight the timeline of this case, highlight what they say is evidence that Clancy was methodical and planning here. They can point to search history on her phone. They can point to the conversations she was having that day. They can point to sending away Patrick, her ex-husband, away from the house before she committed these killings. We'll see how this works out. Closing arguments could be as early as Tuesday.
All right, Peter, thank you so much. We will see you next week, I'm sure, as all of that does happen. Let's bring in Bernarda and Brian for a closer look on all of this. This story is tragic on so many levels. 3 children in Duxbury, Massachusetts back in 2023, a very cold night in January. I remember the story so well. I used to work in Boston. It's resonating with so many people on so many different levels. Bernarda, first question to you. How hard is it for the prosecution to prove without a doubt that Clancy was not experiencing postpartum psychosis at this one specific time?
It's going to be difficult. It's going to be difficult. This is a difficult case, and it's a difficult case because the defense came with the receipts. In the sense of that Lindsay Clancy, it is clear and documented that she was seeking medical attention, that she even went to the emergency room twice, that she was inside, she was admitted into a hospital. She was trying to find a solution. But in terms of what the prosecution is going to harp on is that exact moment when she kills and strangles her 3 kids. And I think the strongest piece of evidence when we're talking about what was she going through at the moment she decided to take an exercise rope and to strangle each of those kids, it's the testimony from Patrick Clancy. Remember, he says that he calls her, she doesn't answer, then she returns his call. Number one, returns her his call. She has the wherewithal to be like, let me call my husband back because I missed his call. And this is probably within seconds, if not a few minutes, of her strangling her 3 kids. Patrick said he didn't notice anything odd. She wasn't saying, I'm hearing voices, I'm going through a breakdown, something is happening, I don't understand what's going on, I don't know where I'm at. That's not what Patrick said. Patrick says she just seemed like she was occupied in terms of probably putting the kids to bed or not. So I think they have to focus on that phone call as well as focusing on the timeline in the sense that there were 54 minutes from the moment that Patrick left the house to when he returned into the house and the timing of what happened during those 54 minutes.
Brian, we've been talking about this term, lack of criminal responsibility. How do you define that lack of criminal responsibility? And do you think the defense has proved that in this case?
So lack of criminal responsibility, or as other states call it, insanity, New York calls it mental disease or defect, it's actually pretty similar in Massachusetts and in New York. And I think New York probably does the best job of giving a real-world example of it in the jury instructions. And the way that New York describes it, it's like a child or a young person singing a song. You can sing the lyrics of the song, but you do not understand nor appreciate what those lyrics mean. Now, when I do jury selection, I know it's maybe not appropriate for this type of setting. I say, I'm born in 88. That means when the song by Genuine Pony came out, I would have been like 7 or 8. I could sing the song,
right?
But I had no idea. I had no business knowing what that meant.
Such a great way to understand it.
And so I think people understand that concept, right? In this, and I think why people will push back, especially if you've lived with a woman with postpartum, if you've had a mother's had postpartum, they can cook and clean and do dishes. They can help with the child. They can do all those things. And then sometimes I looked at my wife and was like, sweetheart, why'd you put the pot inside of the trash can or outside with the dog? She'd be like, I had no idea. And my wife does not have postpartum psychosis. Right. So I think people who experience that kind of brain fog of after having a child.
Mommy brain is what some
mommy
people
brain.
call it, yeah.
I think the psychosis is not that far off as a jump for people to see like what happened here seems much further and much worse than what I could imagine.
I think that's why many people are sticking to this trial too. We've seen the different demonstrators out there outside of court supporting Lindsay through all of this. Bernarda, what do you think about the defense and their decision to keep Lindsay off the stand, off the witness stand?
Is the best decision they made. There is, when a defendant testifies on their own behalf, and this is not a self-defense case, so there's no requirement, I say, for the defendant to testify, it changes jury deliberations, because even though the defense does not have the burden of proving their innocence, jurors start looking and saying, okay, Lindsay Clancy testified, now let's see if we believe what she said, as opposed to, did the prosecution prove their case beyond a reasonable doubt without even evaluating the testimony of Lindsay Clancy? What would you have gotten out of her? You already got the defense from other witnesses. You already got that she loved her kids and never harmed her kids from other witnesses. You already got the sympathy and the emotions in the sense that even doing trial testimony, doing the medical testimony from the medical expert that testified as to the death of these 3 kids, she started bawling to the point where the judge had to take a break from the case. You got that she is paralyzed from the waist down. So you have what you wanted from her without putting her on the stand, because when a defendant testifies also, you can't control the cross-examination. You can control the direct examination. Now the cross-examination, you have to hold it down on your own.
I also want to mention the jury here too, because they're sitting there for weeks on end listening to these stories, seeing the people involved. Vicarious trauma is a very real thing, and I'm just thinking of them too, because they have a lot on their plate. They've been hearing from so many experts. Their world's probably turned upside down of who do I listen to, who do I not listen to. Brian, if you were in their shoes, how would you try and pierce through truth after hearing from so many experts?
So I think what's going to happen here is they're going to forget everything that was said and say, we go and decide. And as a defense attorney, that scares me because I don't think, and we haven't seen closing arguments yet, we'll see who gives the better roadmap, who is more persuasive, because this might come down to just who's the better attorney. It really might.
But when you say that, you mean who's the best at closing?
Correct.
Right? Okay.
Better and more likable and credible.
Right.
Okay.
And right now, if I'm following social media, as the defense, Reddington, he's the guy. Right? These prosecutors don't seem like they really want to be there. It seems like their bosses are kind of telling them to do this gig. So that's why I think I lean more to the defense. But when you have two competing interests in terms of a battle of experts and they both seem pretty credible, I think it's going to come down to how these people relate to the situation in their own life. How did my mother deal with postpartum? How did my wife deal with postpartum? Even though they're supposed to not consider that when they're doing jury deliberation, I think that's going to have a great impact on this. And I could see it going either way.
Mm-hmm. I'm going to have to push back a little bit in the sense the way Brian says that the prosecutor seem like they don't want to be here, like they're just following what the boss says. Because I think it's actually the quite opposite. Because I think that the prosecutors have gotten so close and emotional about this case that they lost objectivity. Number one, in the sense that the female prosecutor, she's wearing bows in her hair practically every day to try to remind the jury about the daughter who liked to wear bows. Remember, she brought it up doing opening statements and now has made it a fact of placing a bow in her grown hair. So that's number one. But also number two, that it's gone so personal that she almost risked a mistrial when she asked the mother as to whether in Catholicism, whether murder is a mortal sin. You don't do that. She's lost objectivity in that regard. So I think
more like incompetence to me than anything else.
You don't think that was just for show?
That's incompetence.
Okay.
She know Bernardo Villalona. That's why.
I feel like we could do a whole episode just on how to properly close cases like this, but we got to go to break. All right, guys, thank you as always, and stick around. Up next, we're going to look at the first week of testimony in the Tupac murder trial, what sparked a heated moment in the courtroom by the defendant. Hey, you're watching Burden of Proof. Let's take a look at the cases 3 decades in the making. The Tupac Shakur murder trial. Duane Keffe D. Davis is accused of orchestrating the rapper's death back in 1996. Davis is the only person ever charged in Tupac's death. He has pleaded not guilty. Jurors have heard a recording of Davis speaking during a 2008 police interview where he claimed his nephew shot Tupac. Now he says those statements he made were false. Tensions and emotions have been running high in this case, 30 years in the making. At one point, some members of Tupac's family left the courtroom when pictures of his autopsy were shown to the public. At another time, Davis had an exchange with the judge about the prosecution.
They keep giving out our address. Now they gave out my sister's address. This stuff is wrong.
I've heard it's going on both ways, that there's concerns both ways.
They're wrong.
I've admonished them to talk to their witnesses and anyone they can communicate about these issues, okay? So your attorney let me know what's going on.
I get beat up by the cops. The guy attacked me in here, sent me to prison. This is wrong, and it's mostly this guy.
For the record, you're pointing Mr. DeJock.
Yeah, for the record, I think he's indicating he's upset I'm prosecuting him for murder.
No, I'm not upset because you prosecute. You're endangering my family's life.
Yeah, we have to talk about this moment right now. Brian and Bernardo are back. Bernardo, let's start with you. What do you make of what we just saw there?
Well, it's a man that he's upset. He's upset. He's frustrated. I mean, Brian and I have had this. I've had this as I was a prosecutor, and I've had it as a criminal defense attorney. But especially as a prosecutor, where defendants get really frustrated, not really understanding the process of how things work, and they want to voice it out because they've already made the complaint to their attorney, and they probably feel that the attorney is not making a record when they want them to make a record. So this is actually quite common. The good thing about this is that Mr. Davis did not do this in the presence of the jury, because it would have been a completely different story for a jury to see him have this type of outburst. Because if you can't control yourself in a courtroom, then for a jury, it's like, wait, hold up. It does seem like you're the hothead retaliatory person they make you out to be from 30 years ago, and here you are now still carrying on.
I feel like if you're Keffe D's lawyer, like, whoa, He just did it once, he might do it again, but this time in front of a jury. Brian, what do you think?
But also, like, listen to what he's talking about. He's talking about the safety of his sister. He's talking about what comments are coming out. And as defense attorneys, we understand that, especially when we have gang cases, we are very focused on trying to make sure that our client is not guilty. Very focused on making sure they're getting the best defense possible. But our words and the prosecutor's words could make people outside of the court very dangerous, could make their lives at risk. Now, prosecutors do it all the time, and they make sure to be very safe when they're saying statements that can make law enforcement get into situations where their lives could be at risk. But we also have to consider the people who are not on trial, who have no relationship to gang activity, and making sure that our words don't put them in danger. And so I feel for Keffe D in this regard, because he's not just having an outburst. He's saying, like, you're putting my sister in danger, and that's real.
Yeah. I want to talk about Suge Knight, because we know that he was in the car with Tupac when Tupac was killed. Tupac was shot. He died a couple days later. Suge Knight pretty much has said, I'm not going to talk. This isn't my job. I don't solve crimes. He said that over the course of years in different interviews, including on ABC years ago. Bernardo, do you think he would ever testify in this case?
Suge Knight is what I would call the wild card. And he's a wild card. Well, number one, it seems like he does want to talk. He wants to talk to everyone but inside of a courtroom because of all these interviews that he's given. But in terms of whether he can be dragged in and to testify in front of this jury, the prosecution has the power to by getting a material witness order signed and forcing him to be produced in Nevada so he can testify. But whether a prosecutor is going to take that chance without having sworn testimony from it prior to him testifying is not going to happen, because you're not going to take that risk. With uncooperative witnesses, as a prosecutor, you want to make sure that you have either one, something that you want them to testify about is undeniable, meaning you have them on tape or you have them on surveillance video, or you have a pre-recorded or pre-sworn testimony from that person. So if they say something that's contrary to what they're testifying to, you can bring in that other statement. But you're not going to do that here.
Could there be a world where he's already testified to police and we just don't know about it yet? Like, in terms of, is this something where somebody could sit down,
like an agreement or something like that, not testified?
But has that happened before?
Well,
I'm just trying to think, like, if somebody's like, I'm not going to talk, but then in court they bring up, by the way, they spoke to police about this X amount of years ago.
No, because that's why discovery laws are in place, in the sense of you have to turn over whatever statements a witness has given if you plan on calling that witness, for the prosecution, if you plan on calling that witness to the stand. At least in state court. Federal court, they play a different game.
Brian, real quick, would you call Suge Knight to stand?
I've done it before. I've had attempted homicide cases where the person who was shot at, I put him on the stand. I had, as Bernardo said, like a little bit of assurance, and he sat there and he said, that person did not shoot me, and the prosecutors got it wrong. So nerve-wracking, but we walked out of it with a not guilty.
What a moment. Wish I was there. All right, guys. Thank you so much. Stick around. Coming up next, the Texas teen convicted of murder is pushing for a new trial, why things got heated in court, and the so-called gentleman's agreement at the center of the hearing. Here is a quick look at another high-profile case on the docket we are watching. Convicted Texas teen Karmelo Anthony appeared in a courtroom as he pushes for a new trial. A jury rejected his claims of self-defense back in June and sentenced him to 35 years in prison for killing Austin Metcalf during a confrontation at a high school track meet. A key sticking point is a so-called gentleman's agreement between the defense in the first trial and the prosecution to not mention in court Anthony's past. That includes stalking accusations from his ex-girlfriend. The defense is accusing the prosecution of not sticking to that agreement, which they say made Anthony change his mind about testifying, and they say he was afraid that his past would be used against him. Let's bring back Brian and Bernardo. Gentleman's agreement. I have never heard of that before. Bernardo, what is it?
And actually, I've never heard of that before in a court of law because it's non-existent. So in terms of this Karmelo Anthony case, this teenager who was convicted in Texas of murder, the gentleman agreement that they're referring to is that both sides agreed not to bring up certain pieces of evidence, and there was a handshake to it. Not that it was put on the record or that the judge was involved in this or that there's anything in writing about this agreement, but rather that, oh, we're two good friends and we we agree on just on face value that we're not going to do this? Bad decision. All across the board. There is no way that I will be entering in an agreement of this magnitude when you're talking about a self-defense case, and I am going to trust either the defense or the prosecution that you're not going to bring up a person's past when we're talking about a trial like this. Huge mistake. I'm disappointed on both sides.
Brian, let's say I'm a lawyer. You're on the other side, and I go, Brian, my friend, let's make a gentleman's agreement on this. What do you say?
So this is how I operate with all prosecutors, and there are many prosecutors who cheered when I left the Legal Aid Society in Brooklyn. We are friends up until trial. I as a defense attorney, you as a prosecutor, we're trying to get the best deal. But once we decide we're going to trial, I am not your friend. We are not gentlemen. There is no cordial decision between us. I will do everything legal and ethical that I can do to beat you because I am representing someone and their life is on the line and their life is in my hand. So a gentleman agreement does not work for me. And if you hear irritation and anger in my voice, it's because this defense attorney was my people. He was a former public defender turned defense attorney, and he thought he could have a handshake agreement. And the reason why Bernard is talking about putting on the record, if you don't say it in court and put it on the record, you can't appeal it and then make an argument. So now you've harmed your client. You took an oath to the Constitution and you picked a job that is crummy and hard and disrespectful. I've been spat at, called the N-word. I've been called horrible things as a defense attorney. But I represent my client. And you did this to a person? No, you're not my people. Like do another job. Yeah. Get out of here.
And now that's why you have a hearing where now the former defense attorney and the prosecutor is testifying before the judge, or had to testify before this judge. And now this judge is going to have to determine credibility of both these attorneys. Now the judge has to determine what was the actual agreement, what was the actual understanding of the agreement, what was the breakdown of the agreement. Look, there's a record for a reason. Anything I need to say that affects my client or even as a prosecutor when I'm presenting evidence is going to be on the record, because we're not going to be second guessing ourselves about a conversation we had in the past. Because usually you can approach and do a sidebar conversation with the judge, prosecutor, defense. But we're going back on the record because I want it on the record.
I'm really curious if this was not appealed, if we would have ever heard about this, but we have to go now. Bernardo Villalona, Brian Buckmeyer, thank you, and thank you guys for joining us. I'm Perry Russom. We are live weekdays with new episodes right here on ABC News Live at 5:30 p.m., 8:30 p.m. Eastern. If you missed any part of today's episode, check us out on demand on Disney+, Hulu, or wherever you get your podcast just by searching Burden of Proof. Have a great weekend.